Item, please.
Item number 85, case number 30159, premises known as 2548 South 29th Street. A request to appeal an order from the Department of Neighborhood Services stating that there is an illegal sign on the premises. I'll take one of these and pass it down.
Good evening. Is there anybody else here to speak on this item?
Got the entire chapter.
There's an extra chair here. Could you state your name and mailing address for the record, please?
Todd Vondre, Department of Neighborhood Services, 841 North Broadway.
Ron Roberts, Department of Neighborhood Services, 841 North Broadway.
Ellen Plecka, 2544 South 29th Street, Milwaukee, 53215.
Elizabeth Hernandez, 1508 North Barwell Avenue, Milwaukee.
Robert Braun, 2160 South 86th Street.
Sir, could you state your name, please?
Oh, Robert Braun.
No,
next
Oh,
to
there we go. Your name?
Brother Ron, 2548 South 29. Brother Ron,
And your last name, please?
STANIS.
Thank you. Could you all raise your right hands to be sworn in?
Do you affirm under oath that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you.
How come you people look so bad? So help me God. How come you people look so sad? It looks like you're going to a funeral.
All right. we'll
Hey,
try
God,
not
your
to-
heart is beating, you're alive and well, you're blessed, you got faculty. Be happy.
All right.
What's wrong with you?
Thank you. DNS, do you have, DCD, do you have anything further?
Nothing additional.
DNS,
Mr. Vondre and Mr. Roberts will
Smile.
speak for us.
you're going to have to let us do our business here. Thank you. Traffic?
I have no comments. Gee whiz.
You have, Mr. Stanis, you have appealed an order that was issued by the Department of Neighborhood Services with regard to a sign you have on your front lawn. Now is your opportunity to explain to the board why we should grant this appeal.
Right.
Excuse me,
And
before
we
you
do-
get started, I'd like to get something on the record that we are requesting that we receive a copy of the transcript. We will pay the fees when this hearing is over with. We want to make sure that we get the record of this hearing because there's an attorney from Liberty Counsel who will be taking this up in federal court if he doesn't succeed. Second of all, I'd like to know if everybody that's sitting there has received a copy of the 9-page brief with the legal arguments in it. That's all I'm asking.
Yes, we
you?
have. We've seen it, and we've had an opportunity to review it.
Okay, what I'd like to do, if I could, is just read from the, go into the last one of these arguments. Every legal argument is on the last page is where it came from, either the appellate court or the Supreme Court. And the only one I'm going to bring up, then I'll let Mr. Sanis take over, is that most residential neighborhoods allow commercial speech in the form of real estate signs. As such, religious, political, pro-life, and other issue-oriented signs may also be displayed on residential property. Certain restrictions may be placed on the display of signs for ethnic purposes or traffic control, but these restrictions will never justify a context-based ordinance. Additionally, if the ordinance is so vague as to leave one guessing as to the meaning of the unbridled discretion in some government official to grant or deny a request to post a sign, the regulation will not pass constitutional muster. Finally, even if the sign ordinance applies to all speech, it may not be so restrictive as to essentially prohibit First Amendment activity. The home is a unique space from which to communicate, and thus the government has very little valid interest in regulating the private display of signs on private property. And the last thing I'm going to say before I'm done is we have noted, and in the record, it states that it's an illegal sign. And I have, in 1 month dealing with this, have yet to see any legal argument coming forth from the city showing not how they can regulate a sign, as a sign can only be on a property for 30 days or it's illegal, and a huge amount of fines are forthcoming if it's not removed. Now, you're quite aware of a lot of signs that Christmas and whatnot are on private property for more than 30 days. And I just drove by some today and seen them. Your measurement of a sign, as you well know, is just making a square around the area of it. But I think we want to stand on this document. It's 9 pages, and I'm done. I'm going to let Mr. Stanis talk, and he, I think, is going to refer to this too. But this is our argument that we're basing our case on, and if we don't prevail here, the next step would be the federal court. So thank you.
Thank you.
Okay. I want to thank God and the committee for giving me a chance to share God's word and the truth. And the congregation back there that came to support me, the donation bucket will be passed later on. Signs mean something that dictates a fact and a quality, okay? I got a thing in the mail. It's called signs for dwellings, except for permitted temporary signs. These are what you're accusing me of. No other signage shall be allowed, okay, underline allowed, but you are hereby ordered to remove any illegal sign. Number one, they weren't illegal, okay? They were put up before Christmas. Actually, they were put up about 1.5 years ago or longer because it was around Halloween. Because my neighbors put up this Halloween stuff, and I'm not into it. So to counteract measures, I put up the gospel, copy of the 10 Commandments. I got a picture of it here someplace to show it to you.
Picture of your sign, we have that.
Or you have pictures of it, right?
We don't
Okay.
need that, we have it.
It's not the size that you're complaining about, because we measured it, and it is 6 foot. Ron Roberts said on the news media that it wasn't, so he didn't know what he was talking about, okay? We measured it, and it's legal in size. Okay, in locations, it's fine, because it doesn't apply, okay? What was the other one?
Read some of that.
The only thing we could think of, as a matter of fact, I was told by one of the neighborhood services directors that it was what the sign said, okay? Now, like I said, I had that sign up there for over 1.5 years to protect my family, to protect my house, to protect the neighborhood. And it works, okay? But I get a chance to preach to the kids and share the good news with them, okay? And what they're supposed to do and not to do. Ever since this mentally ill person moved in, paranoid schizophrenic, who's a atheist, he told me that he was going to seek the city on me because of my backyard, which I have about 3 or 4 other notices that I was accused of doing bad things, which they dismissed, okay? But this one here thing, this sign here thing, what I believe is separation of church and state, that the church came before the state. But they didn't specify which sign it was, because I got the flag up there at half-mast for aborted babies, and I also have a cross laying on the side with a painting on it that says, "Father, forgive them, for they know not what they do." Okay? Now, they didn't specify in this ordinance what sign it was. I also have smaller signs on the garage in regards, since my windows were broken, I've been maced on Thanksgiving by that mentally ill person, who, by the way, lives with her, and he turned her against me.
Yeah, we don't
Okay?
need to hear personal
Now,
attacks. The
now,
other thing is,
well, no, I'm just describing the thing.
I'd like to just say something. This is scheduled for 5 to 10 minutes. And
Okay.
so could you wrap up, please? You've been talking nearly 5 minutes. And
Okay.
we have other people here.
So I'm getting to the point. It's in the Constitution, in your boss's Constitution, all right? The United States Constitution says that vagueness is unconstitutional, All right, so the ordinance that they wrote up, or the complaint they wrote up, is unconstitutional because I don't know what sign they're talking about. I didn't know what it contained, or the size, or anything like that. In page 4, okay, it's called ordinances lacking objective standards. He's kind of covered it pretty good. But it goes on, it really covers it pretty deep, and it's got to do with, for example, the meaning of the word political. To some might connotate things, or connote, how you say it, signs promoting a candidate for elective office, but to others might encompass the broad spectrum of governmental affairs or social debate. In other words, people would take it the wrong interpretation and definition. Words like a cause, issue, personal expression.
We have had the opportunity, I've read the entire thing, so
So the vagueness of the
we just need to have you wrap up now.
The vagueness of the ordinance is unconstitutional due to the fact that it doesn't really specify which sign it is. There are many other things on those sheets, those 9 sheets that he gave you.
And we do have them now. Could you wrap up, please?
Right. Well, what I can say is that there's no cause for complaint. But I've known the lady for 15, 20 years, 30 years, 15, 20 years, and we never had no disagreement about it whatsoever. Okay? I've witnessed to her, I testified to her. She had her heart attack and stroke. I prayed for her and everything else. And this is how she turned around and bite me. Only because of one person, okay? And it only takes one person, just like this sign said.
All right, we got to
And
wrap.
so-
I'm
Could you
gonna have you
testify
wrap up.
briefly? This lady is here for
You
it.
know, you've gone on for like 10 minutes now.
The first one took 15 minutes you had up here. I looked at the clock. So could we have her just briefly?
Well, we have
speak words?
3 other people, so it would have to be very brief.
Go ahead.
I believe it is brief, and as I'm aware of all these things that are happening and being in the work that Ron is in, I believe that God gave us rights, and they're above all of us. Some of us don't recognize that, but someday we will, everyone that's sitting here. And I just stand for what is good and to help this city of Milwaukee with all the evil that's going on. We can make a difference if we show the truth of what God put here for us. And that's all I have to say.
Thank you.
I just want to say
No,
two words.
you're done. We got to go on.
Content
I can't let you
duration.
continue. Okay.
Okay? That was also on.
That's it, all right? We
I'm
got to go
sorry.
on, all right? Now I'm going to give
It's too short.
DNS the opportunity to respond.
Yes, Todd, do you want to explain your inspection?
My inspection was based on a complaint of the sign in Mr. Stanis' front yard. There was no permit taken out. It is a plywood sign approximately over 6 feet tall and more than 6 feet wide. It is a permanent sign. It's not a temporary sign. That's why the order was issued. Signs are not permitted in a residential district, and that was explained to Mr. Stanis.
Thank you. And is there something you wanted to testify to with regard to the sign?
Well, it does not fit in with the flavor of the neighborhood. I do believe that religion and politics should be kept to oneself. I have trouble renting my property because of what's going on next door.
All right.
Could I just get objection to Mr. Robinson? I don't think this, as he says, no permit was taken out. I don't think it was ever asked for. It's not mentioned in the complaint. Why did you bring that in all of a sudden now? It was never mentioned. It's not part of the
He
complaint.
does have, you do have the right to ask you a question. Please.
I'll
I'm
be happy
asking
to
you
answer.
why you brought that up.
Well, I didn't.
As it's not part of the complaint.
Right, we heard but the question now.
Yeah, yes. A permit would be required for a permanent sign. Basically, this does meet the definition of the sign, and it meets the definition of a freestanding sign. And so as of October of 2002, no sign can exist in the city of Milwaukee without a permit, without first obtaining a permit. So you would be required to obtain a permit. You and I have had that discussion immediately after the order was issued.
All right.
Okay, one follow-up question here. I noticed that right down the block there are several other signs that have been up there for 6 months to a year, community watch signs, and there's a property for sale right around the corner. I noticed, I don't think those properties have any permits. It seems to me you're singling out this property and saying it needs a permit. Are you saying right now if you put a permit up, that would be a legal sign? Is that what you're saying?
There is an exception for temporary signs and signs similar to what the gentleman has on the end of the table there that would be commensurate with a residential zone. A sign like that would be permitted on a temporary basis, but as this sign is 6 foot by 6 foot, it is too large for a residential
What
zone.
I don't understand, though, if the Christmas signs are right next door, and I don't see the city of Milwaukee ever coming down on people with Christmas-type religious decorations, and I think that this ordinance, you're saying temporary signs, it doesn't explain if it's 30 days, 60 days, 6 months, what temporary is. This ordinance says nothing. You're pulling it out of thin air, and you're interfering with this man's right to your home. In many of the cases, I think some are in here, the Frisbee Schultz case, that a home is one's castle. People have a right to put up signs. Are you saying, and you cannot show me one law that restricts putting up signs such as if you're running for political office, are you telling me you're going to fine these people thousands of dollars if they got them up more than 30 or 60 days? I have yet to see a case where that was done.
Okay, thank you. I guess there is a question in there. There was quite an argument, but is there a time period?
Yes, 30 days for a temporary sign.
And so does that apply to a real estate sign?
Yes, it does. And the code
But
goes...
real estate signs go up for 6 months at a time.
Yes, and yes, in fact, there is a period that they can have real estate signs in residential zone district. I thought I brought that right here with me. But sale or lease improved real estate, a sign advertising the sale or lease for a building or other improved real estate is permitted and does not exceed 6 square feet. So, and we don't put a time limit here in the ordinance. Basically, it's just saying if it doesn't exceed 6 square feet, that is permitted sale or lease of real estate. There's also other exceptions listed in the code. So in this case, we're not talking about either one of those. So we're talking about the permanent sign.
And is there something in the code that says the 30 days, or is that
Yes.
a matter of practice?
Under exemptions for, basically, we have signs for dwellings, and under the general provisions, we have exceptions. And under the general provisions, political signs, such as signs removed within 30 days of the end of the election campaign period. Again, we go into other signage that is permitted on a temporary basis, provided those signs do not exceed 6 square feet. Under the ordinance, there are approximately 8 exceptions. Signs pertaining to construction of a building, they cannot exceed 30 days in length. Signs that are erected and maintained on lots advertising the leasing or sale of the property, and no time frame is given for that because the leasing or sale may occur, it may take months to occur, but it just says that temporary signs that are erected and maintained on lots advertising leasing, rental, and sale of buildings. I do want to reiterate and this is the general provisions, for a residential zone district, the exception, no signs are permitted in a residential zone except for permitted exceptions. And the type of permitted exceptions would be those temporary signs that do not exceed, as a standard, some of them are 6 square feet is the maximum standard. So there are some exceptions. This sign does not meet those exceptions, and basically it is a freestanding sign that would require a permit and would not be permitted in a residential zone district.
Okay, just excuse me, what you
Now,
said,
I'm
though,
going to have to, we've been going on, these are scheduled for 5 to 10 minutes, so we've
Can I
given you,
rebut him?
we've given you latitude on the time, but I think we are going to have to draw this to a conclusion.
Can we come back?
And I'm going to ask the board members if they have any questions.
Question for DNS. the sign that is in place, you have identified as then a permanent construction, permanent sign,
Yes.
okay? Because it's directly anchored to the ground. Okay, so as then a permanent sign, it does then require the permitting that you alluded to.
That's correct.
Thank you.
Excuse
Not
me,
only
it is
that,
not
it's-
a permit
Hey,
sign.
just a minute, we're asking questions. The board is now asking questions.
And the additional issue is the size of the sign.
That is correct.
I do want to know, with a very short answer, how is this put into the ground? Could you answer that?
I put it up, ma'am.
Yeah,
It's only held on there by coat hangers on a prefabricated posted fence, and it can come down in 5-10 minutes. It's not anchored in, it's not bolted in or nothing. The only thing that's connecting them is coat hangers wrapped around this fence, and also there's a bar that holds the two boards together so that the people can read them. But they're not in the ground, okay? And they're not, they have no metal stands or anything to support them. It's just on a wooden fence.
okay,
Madam
The
thank you.
other thing I wanted to say was
Very briefly.
that the exceptions to the rule that he's talking about, it is a public information sign, by the way, even though the state or the city didn't put it up, because all the public that drives by in section 8B, they read it and they get informed by it. In E, it says any of the following, now these are exceptions. It says any of the following temporary signs, provided such signs do not exceed 6 feet. It does not exceed 6 feet.
Well, what is the size of the sign?
Pardon?
What is the size? It's 6 feet.
It's 6 by something wide, but it doesn't stress the width in their ordinance. What it does stress is the side, the 6-foot height. And see, that was the vagueness of it, because I went to their other ordinances and everything like that, and it didn't apply. It really
Okay.
didn't apply.
All right, we're going to wrap this up. I think we have what we need. Board members, how do you wish to proceed on this?
I'd like to move into administrative review at the next meeting.
Second.
Take the information that we heard here tonight and bring it back for our final determinations at the next meeting.
All right. There's been moved and seconded. All in favor, say aye.
Aye.
Anybody opposed? Don seconded. Anyone opposed? This passes 4-0. What this means is we're not going to take any further testimony, and we did read that, your argument, and so we have had a chance to review it, and we have read it, and we are going to take the evidence that we've received today under advisement. I'm going to also ask then for a copy of the transcript of this proceeding, since you were going to have one anyway, and that will be provided to the board members for our consideration. We're at our next meeting, which is scheduled for March 25th.
Yep.
We will, at the beginning of that meeting, we will make a decision, but we will take no further testimony, no further evidence into the record, no more evidence.
Can we
Is there
go back?
anything, did you want to put
Yeah,
something?
these were the two I was speaking about that I wanted to have admitted.
That's
as part
that's
of-
fine, we will put those in the record. But after we conclude this, there will be no further evidence put in the record.
Can we have DNS submit a summary of their argument, specifying the code, the section of code that they're referring to?
If we do that, then I think then we have to open it up for response to it. So I think we could rely on the transcript.
Give it to him.
Yep.
What's that with that guy?
Okay,
Could I just give him what he's asking for? I think it's under 895-07-8 of the zoning, and I think when he was talking on what he has stated there at the end was under number 8, exceptions. These are
Okay.
exceptions to the rule where his sign would qualify as being an exception.
All right, thank you. All right, so we've moved this into administrative review. The record is closed. I appreciate your all being here. Thank you very much. Thank you. And the hearing is now closed, and we'll go on to the next matter.
Thank you.
Okay, that's it.